The Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin was supposed to settle the debate over how gun laws are evaluated under the Constitution. It rejected interest balancing, dismissed judicial guesswork about public safety, and replaced it with a history and tradition test. On paper, it was a decisive ruling. In practice, it exposed just how much power lower courts still have when they are uncomfortable with an outcome. Bruin did not eliminate discretion, it relocated it. Instead of weighing modern policy concerns, courts were instructed to examine historical analogs. That sounds objective, but history is not self-executing. Judges decide which historical period matters, which laws count, and how similar a modern regulation must be to a historical one. Those decisions determine the outcome long before the analysis appears neutral. One of the most common ways courts sidestep Bruin is by narrowing the scope of the Second Amendment itself. If a court can define an activity as outside the core of the right, it never has to conduct a historical analysis. Carrying firearms in public, certain types of weapons, or particular modes of possession are often characterized as exceptional or novel, even when historical evidence suggests otherwise. Another tactic is redefining the burden. Courts sometimes claim that plaintiffs must disprove the existence of any historical analog rather than requiring the government to justify its law. This flips Bruin's framework on its head while appearing to follow it. History itself becomes elastic. Some courts rely heavily on a small number of restrictive laws from the late 19th century, even when those laws were regional outliers or short-lived. Others expand the relevant historical period far beyond what Bruin contemplated, treating Reconstruction-era regulations as interchangeable with founding-era practice. This selective use of history allows courts to manufacture tradition where none exists. A handful of obscure statutes become proof of a national pattern. Temporary measures become enduring norms. Exceptions become rules. Delay is another powerful tool. Even when a court acknowledges that a law is likely unconstitutional, it often allows enforcement to continue while appeals proceed. These stays can last years. During that time, the ruling has no practical effect. Rights exist only in theory. Courts justify these delays by citing institutional caution. They claim that changing enforcement too quickly could cause confusion or instability. But the practical effect is always the same. The government keeps enforcing the law, and the burden falls entirely on the individual. Lower courts are also influenced by signals from above. When the Supreme Court repeatedly declines to take Second Amendment cases after Bruin, it sends a message, whether intentional or not. That message is that aggressive interpretations are unlikely to be reviewed. Over time, this emboldens resistance. This is not unprecedented. Throughout history, lower courts have resisted Supreme Court rulings they viewed as disruptive. Compliance often required repeated intervention. Without that reinforcement, precedent weakens. Bruin's enforcement problem is compounded by the structure of the federal judiciary. District courts issue injunctions. Circuit courts review them. Supreme Court review is discretionary. Each layer introduces delay. Each delay preserves the status quo. For states, this system is advantageous. Even losing cases can be a strategic win if enforcement continues during appeals. There is little downside to pushing the limits. At worst, the law is struck down years later. At best, it survives long enough to achieve its regulatory goal. For individuals, the cost is immediate. Licenses are denied. Conduct is criminalized. Compliance is mandatory. There is no compensation for years spent under unconstitutional restrictions. The result is a two-track Second Amendment. One exists in Supreme Court opinions. The other exists in day-to-day reality. Lower courts determine which one applies. This dynamic also affects future litigation. Lawyers adapt to the environment. Some avoid sweeping claims. Others focus on procedural victories rather than substantive rights. Over time, this narrows the battlefield. Public perception plays a role as well. When lower courts routinely uphold restrictive laws despite Bruin, it creates the impression that the decision was symbolic rather than transformative. That perception feeds further resistance. The Supreme Court's authority depends on enforcement, not just articulation. A ruling that is not consistently applied loses force. Lower courts begin to treat it as guidance rather than command. Bruin was a clear statement of constitutional principle, but principles do not enforce themselves. Without follow-up, they erode. This is why the question is no longer what Bruin says, but whether it will be enforced. Until the Supreme Court steps in again, lower courts will continue testing how far they can go, and every test that goes unanswered becomes a new boundary.